Welcome to the Insolvency and Law podcast, providing specialist insolvency and debt-related advice for business owners and individuals. For more information on debt recovery, business restructuring, and personal and corporate insolvency, visit our website www.insolvencyandlaw.co.uk or call us now on 020 7504 1300.
Hello, and welcome to the Insolvency and Law Business Advice Show, the podcast dedicated to credit management, debt recovery, and insolvency in England and Wales. In today's episode, we're focusing on winding up petitions and the consequences of presenting a winding up petition to an insolvent company that owes you money. Does a limited company owe you £10,000 or more? Have they accepted payment is due, but still not paid the debt? If the answer is yes to both questions, you can present a court-issued winding-up petition to have the company liquidated. For more information on debt recovery, winding-up petitions, and statutory insolvency procedures, call 0207 504 1300 and speak with a professional independent advisor today. So, let's start at the beginning. What is a winding-up petition? Well, if a company owes £10,000 or more, for an invoice, or some other undisputed debt, you can obtain a court order to have the company liquidated. The winding-up process begins when the debtor receives the petition. If a winding-up petition is ignored, formal insolvency proceedings may commence, and the company could be placed into compulsory liquidation. Section 127 of the Insolvency Act 1986 forbids company directors from taking certain actions once a winding-up petition has been presented. For example, a director must seek permission from the court before they can use any of the company's assets or make payments from company bank accounts. Furthermore, when a company ignores a winding-up petition and fails to obtain a validation order, their bank accounts may be frozen, and the petition will be advertised in the London Gazette newspaper, the UK government's most important journal of public record. The periods immediately before, during, and after the presentation of a winding-up petition can be very stressful. Now would be a good time to negotiate with your debtor. It's likely they will be open to a deal that avoids the company being liquidated. In recent times, many companies have used the coronavirus as an excuse to avoid paying undisputed debts. Most explanations are genuine, however, some are bogus. It's important to understand that you must never use a winding-up petition as a debt recovery instrument. However, it's perfectly okay to use them on a debtor company that cannot pay its debts when they are due. Legally, you are free to present a winding-up petition on any insolvent company that fails to do the following. 1. Pay an undisputed debt of £10,000 or more. 2. Explain the absence of payment, and 3. Agree a reasonable payment plan. Any limited company that disregards a winding-up petition and fails to respond faces being placed into compulsory liquidation by the official receiver. Sadly, we're coming to the end of this episode. But don't worry, if you need more information or guidance on winding-up petitions, you can pick up the phone and call 0207 504 1300 to speak with a professional independent advisor at Insolvency and Law. If you found this information useful, you'll probably enjoy some of the other shows in this series, especially the episodes on creditors' meetings and how to improve leverage and dividend prospects in statutory insolvency procedures such as liquidation and company voluntary arrangement, also known as a CVA. Thanks for listening to the end of this podcast. Goodbye.
Thank you for listening to the Insolvency and Law podcast. If you require additional guidance on any of the topics we covered today, visit the Resource Centre at our website, www.insolvencyandlaw.co.uk, or call us now on 020 7504 1300.